Nowadays, most landowners would expect to be liable if a dead tree fell from their land, harming a person or property on adjacent land. But traditionally, the common law provided immunity in that scenario merely because a tree is a natural condition. The California Supreme Court explained the historical justification for that rule and the reasons to abandon it in the case of Sprecher versus Adamson Companies. Adamson Companies owned an undeveloped 90-acre lot in Malibu, California that encompassed part of an ancient landslide. Depending on weather conditions, the landslide naturally fluctuated between active and dormant cycles and was not impacted by Adamson's activities on the land. Peter Sprecher and Gwendolyn Sexton owned neighboring beach houses across the street from Adamson's lot. In March of 1978, an unusually heavy rainstorm triggered the landslide, which flowed across the street and pushed Sprecher's house up against Sexton's house. Sexton sued Sprecher, seeking an injunction to remove his house from her property. Sprecher in turn filed a cross-complaint against Adamson, alleging that Adamson was negligent in not controlling or correcting the landslide. Adamson moved for summary judgment, arguing that it was exempt from liability because the landslide was a natural rather than artificial condition. The trial court agreed and granted Adamson's motion. Sprecher appealed to the California Supreme Court.